Good morning, everybody, and a very warm welcome to the webinar. I think it's time to get started now. Thank you very much for joining. Well, I would be saying us, but for the moment at least, I'm afraid to say it's me because Sarah's been unavoidably held up with something. So I very much hope that Sarah will be able to join us at some point during the webinar. That's the plan, assuming that that she becomes available, she'll be here, and she's asked me to send her apologies, for that. Well, in this week's webinar, I'm going to be talking about cross-border claims, and in particular, which sort of cases are more difficult from a jurisdiction perspective and which are easier. And Sarah and I have divided up the sorts of claims that there are into higher risk and lower risk categories, and I'm going to be talking about those as we go through. I should emphasize, though, that this is simply high risk or low risk from the point of view of bringing a claim here and arguments that might be raised against that. Of course, each claim is high or low risk as well, depending on its underlying facts, and that's something that we're probably going to be coming back to in the course of the session. As we're going through, please do use the chat, which is hopefully there in the bottom of your screen. Normally when there's two of us, the person who's speaking speaks and the other person keeps an eye on the chat or questions in the Q&A. So long as I remain single-handed, it's going to be slightly more difficult for me to do that, but I will try, and I will try to keep an eye on the chat. So do still put things in there, and if we don't get to your question or comment, then we'll try and respond to you by email afterwards. So with that, I'm going to try and advance to the next slide if I can work out how to do that while I'm on my new computer. Bear with me a moment. So, as I said, we've divided up into high-risk cases and lower-risk cases. And a very brief summary about what are particularly high-risk cases. Essentially, these are cases where whether or not the court has jurisdiction depends on the court's exercise of discretion. And, of course, that means that there is quite a high risk every single time the court's being asked to exercise a discretion that on the particular facts of the case, a court may decide one way or another, and different courts could, in theory, decide the same issue on a different day in a different way and not necessarily be wrong about it. It's inherent in there being a discretion that that gives rise to a litigation risk. So, well, what cases in particular do we mean by this? Well, the obvious one, where the defendant is located outside the jurisdiction, meaning that you need an application in most but not all cases for permission to serve, and the exercise of a discretion by the court there. Also, the example where a defendant is located here within the jurisdiction, but the claimant and the accident or the subject matter of the claim are located abroad. Now, we've got a couple of those examples coming later in the webinar, but in those instances, you don't need permission, of course, to serve out because the defendant's here and you won't be serving out. But the defendant would be able to potentially make an application for a stay under CPR 11(1)(b), and that would be a stay on form convenience grounds. And we have a couple of examples of them coming up in the webinar. And then again, when that's being determined, it is an exercise of discretion, so it is high risk. There's also the question of Scottish claims. It's not something that I'm going to cover in any detail in the webinar, but these are cases also which are going to depend on the court's discretion as to whether or not they can be brought here. So Scottish claims are also going to be in the category of high risk cases. So looking first of all at cases where the defendant's outside the jurisdiction and ones where it's necessary to make an application for permission to serve the claim form outside the jurisdiction. Well, what are the hurdles that need to be got through for that to happen? Well, firstly, the claim must be able to pass through one of the jurisdictional gateways, and we'll be looking at what those gateways are and what they involve in a moment. That's the first most basic step. It's necessary but not sufficient. If you can't pass through a jurisdictional gateway, then you can't bring the claim here. However, the fact that you can pass through one of the gateways doesn't mean you're automatically going to be permitted to bring the claim here, because there's more steps to it than that. So the claim has to believe that the claimant must believe that the claim has a reasonable prospect of success. Well, one would hope that would be the case if the claim's being brought. But also, and this is the crunch point, the court must be satisfied that this jurisdiction is the proper place in which to bring the claim. So, turning to the gateways now, the particular gateways that we're going to be interested in are the contract and the tort gateways, and also the gateway that allows anchor defendants to be brought in as well. And the anchor defendant gateway exists where there's already a claim taking place here, and then there's an anchor defendant already, probably somebody who's already based in the jurisdiction. But the gateway says that there is already a claim against the defendant on whom the claim form's been served other than in reliance on this paragraph. So you can't use an anchor defendant as an anchor defendant. And then in order for your new anchor defendant to come in, there has to be between the claimant and the anchor defendant a real issue which it's reasonable for the court to try. And the anchor defendant has to be another person who is a necessary or proper party to that claim. And there's also a provision there which is related with regards to Part 20 claims. And this is that a claim is an additional claim under Part 20, and the person to be served is a necessary or proper party to the claim or to the additional claim. So quite a similar test for Part 20 claims that as to additional defendants using an anchor. In terms of the contract gateway, this requires a contract that was made within the jurisdiction, or made by or through an agent trading or residing within the jurisdiction, or is governed by English law, or a claim is made in respect of a breach of contract committed within the jurisdiction, or a claim is made for a declaration that no contract exists, where if there were a contract, or if it were found to exist, it would comply with the earlier conditions. And then finally, very briefly, the tort gateway. This requires damage being sustained or will be sustained within the jurisdiction, or damage which has or will be sustained that results from an act committed or likely to be committed within the jurisdiction. Moving on then to the issue of forum conveniens, which I said the third rung in the test, and the one that's going to be the most controversial and argued about in any individual case, I think. So we've put up here the example of the fairly recent case of Alasam and Souvalakakis. Now, this is a claim about Cypriot trusts, so quite a different underlying set of facts to an accident claim, obviously. But what the court has to say in that case about whether or not England and Wales was the appropriate place to bring the claim is potentially relevant in all sorts of different claims. So what happened here is it's a claim by settlors against trustees. The defendants were based here, so there was no need for an application for permission to serve out. However, once the defendant received the claim, it applied to stay it on forum conveniens grounds. And the reason why this is so important is because it's determined on common law principles, and Brussels recast no longer applies. So what we're doing is going back to the rules that applied before that. And the two limbs in the well-known case of Spiliada. And with regards to these, the judge found that that this was a convenient forum on both of the limbs, in fact. And just working through them, as I said, the defendants were based here, and the judge held that that fact remained of some significance, even without the Brussels recast presumption that a defendant should be sued in their home court. The judge then noted that this was the underlying transaction was what's described as an international transaction. So the fact that it was a Cypriot trust and some or parts of the causes of action occurred in Cyprus wasn't of itself a pointer towards Cyprus being a more appropriate forum, because other parts of the transaction were international and didn't involve Cyprus. The judge considered questions of practicality, that's to say, location of witnesses, documents, the need for translations, and need for expert evidence. And on these particular facts, given the international nature of the transaction, the judge considered that these were all quite balanced and didn't clearly point in favour of Cyprus as being a more appropriate forum. Now, this was a case where the majority of the causes of actions were governed by Cypriot law, and the judge considered that that was an indication in favour of Cyprus rather than England and Wales. However, not as strong as it might otherwise have been, because Cypriot law was similar to English law in all relevant respects. Also, there was going to be a need, whether this was in Cyprus or in England, for some evidence of foreign law, namely Swiss law. And this illustrates that the way these balance could be different depending on which alternative jurisdiction you're considering. So it was obviously a factor here that the potential alternative place for this case to be heard was Cyprus, and Cypriot law was similar to English law. If it was an alternative jurisdiction with very different legal system and different law, and that the foreign law applied, that would be a factor more strongly in favour of the other court as being the appropriate place. The judge also looked at the overall shape of the litigation and considered this didn't show Cyprus to be a more appropriate forum. And that wasn't affected by the possibility of contribution proceedings against a trustee who was domiciled in Cyprus. So on the facts of that case, and considering all of these matters that are in here, no stay was granted in this case, and the claim will proceed here. The facts of the case, are, like all cases, are very specific, but on here, these bullet points, I hope are helpful guidance for the sort of factors that can be relevant in these applications, and hopefully these will assist in how to frame an argument that England and Wales either is or isn't the appropriate forum, depending on which way you're trying to argue this. Now, there are some other cases about personal connections and residence, and these two cases that I've put up here really do pull into rather different directions. So the Chowdhury case, which is in the Chowdhury case, the question that was being grappled with was whether an individual was resident in England. Now, he had been in Germany since 2018, seeking medical treatment for injuries arising from a road traffic accident. And it was successfully argued that the claimant had not abandoned his place of habitual residence at the time the claim was issued, because he was intending to come back. Although he'd been in Germany for quite a long time, it was essentially temporary because he was having medical treatment. Now, this is a very different result to State and Cosmos. And the claimant in this case was in the RAF, and after October 2016, he was posted to Cyprus. Cyprus is coming up quite a lot in this webinar for some reason. Now, the claimant's evidence was that he intended to return, that he was in Cyprus because he was posted there by the RAF rather than because this was his habitual residence. In October 17, he was injured in a traffic accident in Cyprus, and he brought proceedings here. And the defendant applied for a declaration that the English court did not have jurisdiction. Part of the defendant's arguments was that the claimant wasn't resident here when he issued the claim. And the judge dealt with this in a different way to Chowdhury, holding that the claimant must positively satisfy the court that he was residing in the jurisdiction at the time of the issue of the claim, without reference to what had gone before. And what this meant was the fact that he was a British national, his immigration status here, his family connections here, etc., all fell away. And the only real evidence was then the fact that he was in Cyprus at the time. And the judge found he couldn't establish habitual residence within the jurisdiction at the time of issue. So this is quite a controversial decision. As I say, it's essentially the opposite result to the Chowdhury case, and perhaps unsurprisingly, it's under appeal. So watch this space. We may be talking to you about this case in future to say that the decision has been overturned. Then the question of factual connections. And I draw this to your attention because this is another case where the defendants are here, but the claimant is actually abroad. So this concerns a pre-Brexit skiing accident in France. As I say, the defendants in England and the claimant in France, both were skiing, and the French claimant's case is that the English defendant skier essentially negligently caused an accident. Although the accident took place before the end of the Brexit implementation period, the case was issued afterwards. So this is dealt with under all of the new rules rather than the old ones. And so perhaps unsurprisingly, the defendant applied to stay the claim on grounds of forum non-conveniens, saying that this case should properly be heard in France rather than in England. Now, one key issue in this case is that liability wasn't an issue. So the claim was simply a case of quantifying the damages in the case. Of course, that would be subject to French law, and the court would need to be doing a French law damages assessment. And the defendant argued that that was more properly done in France. Now, the test in Spiliada is whether the defendant can show that the other jurisdiction, so France, is distinctly or clearly the more appropriate forum. And the court held that the defendant hadn't satisfied that test of distinctly or clearly the more appropriate forum being France. And the fact that liability was admitted was evidently a key part of the reasoning. The other issues were that as the defendants were here, enforcement would be taking place here, and that would be more straightforward if the judgment was from a court in England and Wales rather than a court in France. Also, the defendants' lawyers were English. The case was a quantum exercise, as I've said, under French law. English courts are perfectly able to deal with a French law claim like that and have done many cases like that that we've all been involved with, I'm sure. The claimant's experts were in France, however, so that was a factor pulling in the other direction. But the claimant had already done work on her case here, and that, plus the English cost rules, were a legitimate personal and juridical advantage and were special circumstances in favour of England and Wales being the appropriate forum. And on here in this slide, I refer to evidence, convenience and expense, aka juridical advantage. As I've said, one of the key features in the Khalifa case. costs, funding, and enforcement. We also mentioned the language of the proceedings. Without dwelling too much on the VTB case, this is one that went the other way. The alternative forum was Russia or England and Wales. And part of the reasoning for the decision, the court held that there were heavy factors that Russia was the forum conveniens. And part of it was the case depended on the state of mind, motive, and actions of key witnesses who were all in Russia and would be giving evidence in Russian. All of the documents were in Russian, and the language of the case was Russian, as well as it being Russian law. And I think that does draw a distinction between the case of Klifa, where it was quantum only, and it didn't involve having to do an assessment of the state of mind, motives, and actions of the defendant skier, because liability had already been dealt with. Whereas in the VTB case, which was very complicated on the question of liability, the court took the view that it was going to be in some relative difficulty dealing with these issues all through translated evidence and documents, and these problems wouldn't arise in Russia. So the language of the proceedings can make a difference and can certainly be a relevant factor pointing one way or another, as per the VTB case. And as I say, applicable law, Russian law in the VTB case, that was a factor in favour of Russia. In Klifa, it was French law, but because it was a quantum-only exercise, the court didn't consider that, stopped England and Wales from being the appropriate forum. An overall shape of the litigation I've addressed already. So these are all very relevant factors when looking at this issue of what's the appropriate forum. And we've now got a question of an example, and I think I'm going to ask for some comments about this in the chat. So I thought for a moment I might try and do a poll, but I think I might be exceeding my IT competence by trying to do that. So here is the example then. Both claimant and defendant are domiciled in England, and the road traffic accident occurs in Greece. So can I have some responses to that in the chat? We've got a lot of England coming up. Some more England, some more England, some more England. Come on, England. Well, it seems like everybody's pretty unanimous on that. Oh, we have some Greece. So we have almost overwhelmingly England and a couple of Greece. Well, I agree with that. The claimant and the defendant are both domiciled here. Applicable law is going to be English. They're both here. It's simply the case of the accident taking place in Greece. Lots of the documents, etc., are all going to be here. So I agree that that's England. But of course, the fact that you can make an argument for Greece demonstrates that even this one is a high-risk case. Well, what if we change the facts a little? So let's say the claimant is Greek, and the defendant is here, and the accident was in Greece. So this is similar to the Klifa case. What do people think? Now here we've got a much more balanced view with, I'm not going to count them all up, but quite a few people saying Greece and quite a few people saying England. And somebody's saying it depends on the fact of the case, and I think that probably is the correct. I think that probably is the right answer. Well, I think it does depend on the facts of the case. We've got, if we've got a claimant in Greece and a defendant here, it's going to be like Klifa. This is going to be governed by Greek law. If we have liability admitted, then can make an argument for it being in England if there are these other special factors. But absent them, then it may well be that Greece is a more appropriate forum. Now, the final one, if we have the claimant here and the defendant in Greece and the accident in Greece, what do people think then? I've just fast forwarded to the next slide, but yes, I think in that situation it's going to be more difficult to argue for England, but it's not impossible. All right, I've got a few more examples. If I just advance this. So now this is concerning an insurance question. So we've got a claimant domiciled here, and we've got an accident here, and but the car was insured by a Greek insurer, so it's presumably a Greek driver who's come over quite a long way from long journey from Greece in the car. So in this situation, we can't rely on the Odenbright jurisdiction anymore, and the Greek insurer can't be served in England. So this is a situation that used to be very straightforward before the end of the Brexit implementation period and is now much more difficult. So if we look at Article 4.1 of Rome 2, that tells us that the law of the accident is English law. And that doesn't really help us because English law doesn't provide a direct right of action against a Greek insurer like this. The European Community's Rights Against Insurers Regulations 2002 only cover vehicles normally based in the UK. And I suppose it's possible that this Greek insurer insures a vehicle that's normally based in the UK, in which case English law would allow this. But assuming that the vehicle is not normally based in the UK, then the European Community's Rights Against Insurers Regulations doesn't help. Now, is there another answer? And if we look to Article 18 of Rome 2, that says that there can be a direct action against the insurer of the person liable in two circumstances: if the law applicable to the non-contractual obligation permits it. Well, I don't think it does for that reason said. Or the law applicable to the insurance contract so provides. So the law applicable to the insurance contract is presumably Greek law, which does provide for a direct right of action against the insurer. So there is a way through the rather tangled mess of that one on this example. Now, moving on to my final example. So this is contribution and indemnity situation. So imagine a case where a claimant brings a claim against a tour operator under the package travel regulations, and the defendant tour operator wishes to pass on liability to its supplier. Well, in that situation, the defendant obviously has a choice. It can either bring the supplier into this action with a Part 20 claim, or the defendant can wait till the conclusion of the claimant's claim against it, and then if the claimant succeeds, bring an action against the supplier at a future time. And if they brought in the action now, then it would go through the gateway as I was discussing earlier. But there are pros and cons in favour of both courses of action, as I'll come on to in a moment. So in favour of a Part 20 claim, well, there's an obvious advantage in dealing with everything all at one time and also all before the same judge. No risk there of any inconsistent decisions or findings of fact, and all decisions will be made on the basis of the same pieces of evidence. You also, if you're the defendant, have the potential advantage that the supplier is much more likely to cooperate if they are a party to the action. And so that may well mean that the defence is more likely to succeed. Certainly, they're not going to, much less likely to have the situation where the tour operator just has a wall of silence and non-cooperation from the supplier, and then nothing to counter what the claimant has to say about things. You've also got no prospect of the supplier arguing down the line that the tour operator somehow failed to mitigate by arguing in a certain way, or not taking certain points, or not trying to get certain evidence. But there is one big factor against a Part 20 claim, and that is the way that the costs rules work. So imagine if the defendant succeeds, then the claimant's claim is subject to quox, and the costs order in the defendant's favour is probably not going to be enforceable. The rules for Part 20 claims are different, though, because the Part 20 claim is not subject to quox. So if the defendant wins against the claimant, the result of that is that the Part 20 claim is going to fail because there's nothing for the supplier to indemnify or give a contribution towards. And in that situation, there is no quox protection for the defendant against the Part 20 defendant. So ordinarily, the defendant would end up having to pay the Part 20 defendant's costs, not subject to quox. So it actually puts a defendant in this situation in a really paradoxical position, because bringing in the supplier may mean that the underlying claim is more likely to succeed. However, the better the defendant does in batting off the underlying claim, then if you've brought in the Part 20 defendant, the worse the situation is for the defendant vis-a-vis the Part 20 defendant because of costs liability. So you could say that the stronger the defendant considers its defence is, then the less argument there is to bring in the Part 20 claim. But conversely, if the defendant's got some real concerns about the prospect of success, then it might make more sense to bring in the Part 20 defendant to have them in the action at the same time. Then, well, that's arguments about bringing in the Part 20 defendant. What about arguments the other way? Well, in favour of this, as I've mentioned, costs. If the claim fails, the costs of a Part 20 claim are saved, and that's the defendant's costs and the Part 20 defendant's costs. But there's also the problem that a different claim brought at a different time in front of a different judge. You've got jurisdictional uncertainty about whether this claim is going to be allowed. There's also the possibility of the Part 20 claim failing on the facts if there's slightly different evidence or some additional documents that weren't there in the main action. So it's going to be a really fine balancing act. And it seems to me it's going to depend on the strength of the underlying claim, as I've said, but also on the terms of the indemnity. Because if there's a very strict indemnity that requires no more than for the claimant to have brought a successful claim, then in a situation like that, there's not going to be the uncertainty about whether the indemnity is going to be provided or not. Also, if the underlying contract is very strict about requiring the supplier to cooperate, then if there's something like this happen that we've said on here, that some new documents and things come out of the woodwork, it would be possible for the defendant to argue that there was actually a breach by the supplier of the supply contract in failing to cooperate. So the stronger the claim, or the stronger the defence of the underlying claim, and the stronger the terms of the indemnity, it seems to me, the weaker the argument is for bringing in the supplier. And of course, those would all apply in reverse. Well, I'm going to move on now from the high-risk cases to the lower-risk cases. As I say, that's only lower risk in regards to these jurisdictional and procedural arguments. The cases themselves could still be very low risk in respect of the underlying prospects of success. So this other category is where essentially some categories of claim that would have fallen within recast Brussels, where we have preserved those rules as a matter of our own domestic legislation in the new sections of the Civil Jurisdiction and Judgments Act 1982. And these are sections 5A, B, C, and so on. Well, these are quite particular areas where essentially we proceed in a very similar way to the old rules. And they are two areas. They are consumer and employment. And in both of these, it's necessary to fall within these rules that the subject matter and the nature of the proceedings would have been within the scope of recast Brussels. And when these provisions are interpreted, the court is going to look at pre-Brexit exit day case law. So it really is going to be business as usual with these when you fall within them, and we should be within familiar ground for them. So moving on to consumer contracts. Apologies for the flipping around. So this is section 15B, and I've put part of the section here up on the slide. And this is consumer contract provisions. So you can rely on these rules where you have a claim relating to a consumer contract where the consumer is domiciled in the United Kingdom. And where you've got a contract like that, then the consumer can bring proceedings either in the part of the UK where the other party to the contract is domiciled, or in the courts of the place where the consumer is domiciled, regardless of where the other party is domiciled. So they can be outside England, outside the UK, they can be anywhere. Now, this, of course, begs the question, what is a consumer for the purposes of these rules? And also, what is a consumer contract? Well, the answer to that comes in section 15E, which gives the interpretation sections for section 15. So to be a consumer, then you have to conclude the contract for a purpose that can be regarded as being outside your trade or profession. So fairly familiar definition there, which echoes Brussels recast. Then consumer contract, it's to do with the other party to the contract. Do they pursue commercial or professional activities in the parts of the UK where the consumer is domiciled? Or do they, by any means, direct such activities to parts of the United Kingdom, including the part where the claimant lives? And as you can see there, there's an exclusion at the bottom. It doesn't include a contract of transport other than a package contract. So the controversial section here, and the section that's likely to pose the most difficulty, I think, is in little c2. What does it mean for the other party to direct such activities to that part or to other parts of the UK where the consumer is based? And fortunately, I mentioned before that their previous, the pre-Brexit case law will continue to apply here. And fortunately, we do have some case law that deals with this exact point. So here we have the European cases of PAMA and Hotel Alpenhof on there. And these considered in some detail the question about whether whether the commercial activities were being directed by any means. And the decisions hold that the question is whether, before contracting with this particular consumer, the trader envisaged doing business with consumers in the state of the consumer's domicile. Simply having a website, which of course will be accessible from anywhere in the world, is not sufficient of itself. But there are a list of matters that are set out in this case that are described as being non-exhaustive, matters capable of constituting the evidence that the other party was directing their business in this way. These are the international nature of the activity, a mention of itineraries from other members, of people from other member states going to the place where the trader was established. So let's say we've got a trader in France, and the website's full of testimonials from people in various different countries, and the trader saying we provide our services to these places. The use of language can be important. So if you use on the website a language or a currency other than that generally used in the member state where the trader is established, then that's going to be a useful piece of evidence of directing proceedings here. So use of pound sterling payments or numbers in pound sterlings on a website is going to be quite helpful for that. Then mention of telephone numbers with an international code. Then outlay of expenditure on an internet referencing service to facilitate access to the trader's site by customers domiciled in other member states. So this is quite technical, but if the trader is actually using technology to direct their website in the direction of consumers overseas, then this is going to be quite important evidence. Then, similar to the one I mentioned earlier about mention of itineraries from people from other member states, mention of an international clientele composed of customers domiciled in various member states. Now, of course, that particular list very much comes from the fact of the two cases of Pama and Hotel Alpenhof. It's not exhaustive, these are examples, but they are quite useful. It's not sufficient that it's possible for a consumer to enter into a contract by this overseas entity. Just having a website is not enough. You're going to need to have some more. And here are some examples of that. And what that means is not all contracts involving consumers are consumer contracts for these purposes. But of course, where there is a consumer contract, as defined here, then these sections are very useful because they mean that you can bring the claim here as of right without all of the other problems that I was talking about earlier. And that's why they're in here as being in the category of low risk cases. So some examples of this, and there are plenty. Cosmetic surgery may well have happened pursuant to a consumer contract within these provisions. But of course, not necessarily. It's still possible that somebody going for cosmetic surgery abroad hasn't contracted with an entity that's directing its business towards people in England. It's going to depend on the circumstances. You're going to have to look at it to see how they all tie together. Also, accommodation contracts. If you have a hotel that's marketing itself here, or indeed another sort of event, a museum or a theatre, for example, all of these might potentially be consumer contracts, depending on the facts. Now, these consumer area does give rise to a few areas of difficulty. So this is an intermediate category of medium risk cases. And the situation arises sometimes where the person who's the claimant isn't actually the person who physically entered into the contract. And so you can imagine having this situation quite often with family groups, that one person buys everybody's ticket, or groups of friends similarly. What scope is there for a defendant to argue that somebody in that situation does not fall within the category of a consumer able to bring these here? Well, this question was litigated in the case of Lackey that I've put up on there. It is important to say, though, that the Lackey case concerned Brussels recast and not the new English rules in the Civil Jurisdiction and Judgments Act. they are very, very similar, but they are not completely identical. And in fact, in Brussels recast, there's at one point reference to a consumer rather than the consumer. And a consumer sounds more general and gives the impression that that's supposed to intend to refer to a potentially a wider category of people than the consumer as defined earlier on, being the person who's entered into the contract. So in the Lackey case, based on, which was, as I say, on Brussels recast, it was held that the Brussels recast provisions are wider than simply referring to the person who has entered into the contract, and will cover the person who is the beneficiary of a consumer contract as well. And I think there remains an open question how the section 15 is going to be interpreted on that, and if it's going to be interpreted widely as well. The pre-Brexit case law is going to be relevant, but it's not interpreting exactly the same provisions on this issue. So that's an area of medium risk. However, more helpfully for the post-Brexit landscape, in the Lackey case, the master held that in any event, the claimant was a party to the contract. Although her friend had physically signed it, the terms and conditions of the contract made her a principal. And that's going to be the situation in lots of cases, I think, where somebody buys somebody else's tickets for something. It often says in the terms and conditions that everybody who gets the ticket is a principal and is bound by the contract. So these provisions, the master had no difficulty applying them to a situation where the consumer was a party to the contract that had been entered into through his or her agent, which is the analysis that was found to be right here. So, reason to pause for thought, though, if you've got a consumer who didn't themselves sign the contract. There's also the case of Schrems and Facebook, and this is a very unusual case. The claimant sues Facebook on his own behalf, and then also took assignment of many other claims where the claimants themselves were consumers. So he was bringing his own claim and lots of other consumer claims. And Facebook argued that the claimant had ceased being a consumer in respect to his own use of Facebook because he was essentially claim farming and using it as a business. And that argument didn't work. But Facebook also argued that the consumer provisions about jurisdiction were personal and can't be transferred from someone who is a consumer to somebody else. And the court agreed with that. So and they held that the special system in Brussels recast was inspired by the concern to protect the consumer, and that this was only necessary insofar as the consumer was, in his personal capacity, the claimant or the defendant. So that right was lost when the claim was assigned to somebody else. I'm mindful of the time, so I'm going to speed up a gear. The other category in section 15 of the Civil Jurisdiction and Judgments Act is employees. And I've put the section here up on the screen. This section applies when the claimant's employer is here, wherever the claimant is working, or if the claimant is working here, wherever the employer is based, or if you've got an employee who doesn't habitually carry out work in any one part of the United Kingdom or indeed in any one country, if they've been engaged through a business based here. So it's limited provisions where this applies. You have to make sure you fit in one of them if this is going to work. But it doesn't apply to all employee cases. So if you've got a claimant who is based in a particular country abroad and the defendant is abroad, then this won't work. Now, what kind of cases could this apply to? Well, it could apply to accidents at work where you're suing the employer under the employment contract. It could theoretically apply to accidents on the way to work if this is within the scope of the employer's obligations. A case like that is one that might be low risk from a jurisdiction point of view, but high risk from an underlying facts point of view. And I'd make the same point about these other suggestions, cases about inoculation or health. If you're suing relying on the employment contract, then you can fall within these provisions and the claimant is entitled to sue here, providing those categories apply. But of course, that doesn't mean the claim is going to win. You have to have a good underlying claim. Now, this is very much at the end because I think we've actually run out of time already. But I just wanted to say a few words about the Italian Torpedo. Of course, the technique to prevent a defendant from being sued in courts of jurisdictions that are perceived to be disadvantageous. Normally, this is to stop a claim being brought here, although sometimes it's used here to stop a claim from being brought somewhere else, notably the US. Well, how to do this? As per the slide, the defendant brings proceedings in its home court seeking a declaration that it's not liable to the claimant or that its liability is limited, or seeking damages on behalf of its insured. And you do that before the courts of the disadvantageous jurisdiction are seized. So the claimant doesn't find out about it. And then the next thing the claimant knows, there are proceedings underway abroad which prevent the proceedings from starting here. And we've got some suggestions here on how to deal with it. So the parties have to be the same in both actions. If the insurer torpedoes in his own name, you may still be able to bring a claim against the insured or related company, not the insurer, depending on the circumstances. You also have to have the issues being the same in both proceedings. So if you can frame the issues in the second claim differently, then you might be able to defeat the torpedo. Oops. And then, most controversially, how to prevent it. Well, the only surefire way of preventing it is to preempt the torpedo, to effectively sink the battleship before the defendant knows that you're there. And that means issuing the claim here. So you seize, the court here is seized first. Now this has some pretty obvious disadvantages. If you do that, it involves issuing preemptively without notifying the defendant, almost by definition failing to follow the protocols, also issuing before you're ready. And in a situation like that, of course, you are exposing yourself to potential adverse consequences. The court is entitled to look at a failure to comply with the protocol when ordering costs. And that's not just costs that are caused by not complying with the protocol, but potentially costs of the litigation as a whole. If this cause of action is taken, it seems to me it's very important to set it all up to make sure that it all looks as reasonable as it possibly can do. One possibility is to ask the court to deal with the claim in a similar way to where a claim is brought protectively with limitation running out, and to ask for the claim to be stayed very soon after issue so that the protocol can then be caught up with. And that would be one way of mitigating the fact that you haven't complied with the protocol, and then ensuring that when the case essentially comes back to court, the protocol's been caught up with. And if that happens, then hopefully the court will look relatively benignly on the fact that the protocol hasn't been complied with. Well, I think we have completely run out of time, and I apologize if I haven't reached your question yet, but don't worry, we will endeavor to get back to you in email about that. So I am going to sign off now and say thank you very much for your time. I'm very sorry that Sarah wasn't able to make it, but I hope you've had a good session nonetheless, and hopefully see you all soon. Bye-bye.